A very good morning to all my dear students and a very happy Basant Panchami, happy Saraswati Puja, Mr. Dhairya and Karishma, Chetan, Harshita, all those who have sent wonderful wishes. Good morning, children. A very good morning to all of you. And I'm so glad that all my students are studying really well. That's the reason we have got few queries also early in the morning. So let's begin the session with a very warm welcome and a good morning. Mr. Praveen Bharti, he says he's the first one to attend the class today and will I be able to cover my chapters? Definitely, Praveen, you can refer to the recorded lectures. The ICAI Institute is really working and making hard efforts so that the students can stay updated. All the lectures that we take here are recorded on the ICAI portal. You can just go and refer to the recorded lectures. And now onwards, please try to be regular in your classes. Good morning, Shambhi. Chandan, Muhammad Ali, Manisha, Dinesh, Sridhar Das, good morning. Dhairya Verma, Nikita, Gopal Krishan, Jaspreet Kaur, Karishma. Aditya Sinha has sent a very nice good morning and a query for us, and we'll definitely try to resolve that as well. Hriday Gupta, good morning, Hriday. Shiv Tripathi, Meher, Abhinav, Sarvesh, Bhumika, all of you, very good morning, children. All right, so as we always begin the session, first I will be taking up your queries because I know my students have revised the context and we'll answer that, and then we'll be heading towards the last topic of Indian Partnership Act today, that is registration and dissolution of the firm. And yes, I also rightly remember that we have left to discuss one important examination paper, which I told you that we'll be taking up that paper today, and then onwards we will be continuing towards the completion of syllabus. So somebody was asking, Manisha Tehlani is asking about to explain section 13. You want me to explain once again? Or I think you were asking, section 13 specifically relates to your rights and liabilities, child, about whatever the rights and duties we have been discussing. So if you just simply go to the study material, you simply have to read the analysis of section 13. So the analysis briefly explains you what all rights are available to the partners, whether he has the right to interest and capital, advances, what are the rights to remuneration, all those rights you have to learn. All right. Okay, now going forward, somebody was asking, can majority of the partners exercise the expulsion? So we discussed that the expulsion of partners can happen even if the majority of partners agree. However, in the case of admission of a new partner or minor is being admitted, then all the partners need to give the consent for the same. All right. So yes, you are right. Even if the expulsion, a majority of the partners can exercise the right. Karishma is asking about the rights and liabilities of a new partner. So we discussed when a new partner is joining the firm. Say, for example, today, 5th February 2022, Karishma, you joined certain firm. So if you have joined a firm as a new partner, so whatever are the liabilities before 5th February 2022, you will not be held liable for that. So the only difference was we discussed that a minor has been admitted for the benefits of partnership, and later on, if on the failure of 6 months, he failed to give the notice, or after becoming major, he decides that, yes, now I want to continue as a minor, then for all the liabilities with the retrospective effect, the minor becomes liable. Otherwise, a new partner who is joining will not be held liable for those previous liabilities. So Aditya Sinha is asking, if a nominal partner, like we discussed, if a Shah Rukh Khan has lended its name, okay, so it is a reputation because of which we get the business. And if he wants to leave the firm, does he have to give the public notice? Because nothing is written in the study material about this. That is why I'm asking. Okay, so we have learned that any partner who is leaving the firm needs to give a public notice. So this is when we go to the topic of retirement of partner. So I specifically told you in case of a death, insolvency and a dominant partner, you don't need to give the public notice. Now, similarly, in case of nominal partner, if we are getting the business because of that nominal partner, so since the material is silent about this, law is not saying anything, we will assume that similarly, that nominal partner also needs to publicly announce. You have to highlight someone that now this person is no longer associated with reputation. A credibility was built in the market. So even if a nominal partner is leaving, we have to give a notice. We have to inform that he is no longer a partner with our firm. Good morning, Pooja Swami. Okay, Kushagar Tiwari, good morning. Lakshmi, somebody has written, ma'am, can you read my query? And your question, this is what I've just received, that can you see? Yes, I can see. If the firm is declared insolvent, Karishma, then we have discussed, I hope my voice is audible to all of you. All right. So we discussed that the firm has become insolvent and the official assignee is appointed, and all the assets of the firm lie with that official assignee, and that official assignee will dispose of your assets and will pay off your liabilities. She's asking what will happen in the case of minor. So I told you it's only exception in case of a minor. If the firm has become insolvent, minor's share of profits needs to be paid back. So whatever interest, whatever profits a minor was having in the firm, he will step into the shoes of the creditors. He will stand in front of you, and just the way the official assignee is paying to the creditors, they also need to pay back the interest share of profits to the minor. All right. So let me just take out the presentation that we will be taking up today. And meanwhile, we'll just take up the queries first. What do we have to write in the consequences? Harshita is asking about the consequences of minor as a partner. So the paragraph that is given in a study material analysis of section 30, you first have to read the rights and liabilities as a minor. And if you're asking what will happen after he becomes a major, so the second last paragraph, 2 paragraphs that they have given, the rights and liabilities, what happens if he becomes a major? Separately, you have to give the rights, and separately you have to mention about the liabilities. Definitely, Mr. Abdul, if you are studying the study material and the RTPs, everything is sufficient, and as well as you're going through my notes also. So that is sufficient for your syllabus. Okay, so many students are active today with their queries. So that's definitely good. So I hope insolvency point is clear. Ms. Bhumika, happy Basant Panchami to you as well. Pooja Swami is there. If retirement and admission leads to change in the constitution. Okay. So Mr. Parth Gangwani, definitely, even in today's discussion, when I will be teaching you, child, about the registration of the firm, we will be talking about the same points where the subsequent alteration happens. So you're absolutely correct, Parth, where you say that in case of a death and retirement, the constitution of the firm changes definitely. So when we discussed today about the dissolution of the firm and dissolution of partnership, so these are the points where the partnership gets dissolved and a new constitution of the partnership is made. Example number 13, somebody is asking, so Pooja Swami and there was another girl. So once we go to the study material, please remind me, we will open that example and we will specifically understand it from that. Hira Hussain, you're still confused with section 23. So what is something in the section 23 that is bothering you? We simply discussed that section 23 means if any act has been done by one of the partner children, it will be assumed that whole of the firm is liable. Simple. वहां पे जहां section 23 आपका लिखा हुआ है, Miss Hira, you can simply write down over there. Admission means actions taken by a partner. So whatever actions are taken by one of the partners, whole of the firm becomes liable for that. Shiv Tripathi, we can't sell goodwill separately, but see, Shiv Tripathi, section 14 is trying to tell you that goodwill is a part of partnership property. So whenever you're disposing of the partnership property, when you're charging for the goodwill, that means that's absolutely correct because you're selling off the partnership assets and now you're selling off, you're getting the payment for the goodwill as well. Therefore, that is also considered to be the partnership property. That is what the section 14 is trying to tell you. And also they try to tell you that the partnership property can only be applied for the purposes of the business of the firm. Definitely, Lakshmi, section 29 application we'll be discussing in the examination question paper. So thanks for reminding once again. Mr. Mayur is also talking about the same. Manisha is also talking about example number 13. Let us first take this example number 13 only because many of you are stuck in the example number 13 and somebody is stuck between section 29. So let us take these small queries that you have, children, from the study material, and then we will proceed for the question paper also. And then we will try to wind up the session with the last topic, that is registration and dissolution of the firm. But now you want me to open relationship of partners, right? Okay, so let's go to the relationship of partners first. So example number 13, which many of you have been asking, it says mere retirement of the partner who was tenant of the premises in which partnership business was carried would not result in assignment of the tenancy rights in favor of the remaining partner, even though retiring partner ceases to have any right or title in the trust. Children, remember I taught you about this Vishnu Chandra versus Chandrika Prasad Supreme Court judgment, wherein I told you that it is not necessary that even in case of retirement, the partnership business comes to an end. It says if any partner wants to dissolve from the business in a clause of partnership deed, which was comprehending a situation that the partner wants to retire. So how does a retirement happen? It is simply mentioned in the agreement that the partner can retire without bringing an end to the subsisting relationship between other firms, between other members. So means if you are retiring from the firm ABC, there are three partners. If Mr. A is retiring, the relationship of B and C can still continue in the partnership firm. You will still have a relationship with the third parties. It does not cover a case where partner withdraws a firm from dissolving it. So it is not the case of dissolution. It is the case of retirement of a partner. So it should, otherwise it should have to be a proper dissolution and not as a retirement. So it says retirement does not necessarily dissolve the firm. And this is something which we are going to talk about in dissolution of firm. So this specific example you'll understand in much better way once we discuss about the dissolution of partnership today. So there are two different types of dissolution, children. One is dissolution of firm. Entire firm has decided to come to an end. They are no longer happy with the relationship that they were having. Now they want to wind up the firm. They want to close the business. And another is a case of dissolution of partnership, where the partners have decided that now we will be changing the composition. A new partner is coming, or a partner is retiring, or death of a partner is happening. Law says that is simply the dissolution of relationship between the partners. The firm still continues. So similarly, it is trying to tell you over here that a mere retirement, so just a retirement is happening, will not result in assignment of his tenancy rights. So he was a tenant of the premises. The tenancy rights still remain in the favor of the remaining partners. They will still be liable for those specific tenancy rights. Although the retiring partner is now no longer having the interest in the business, but he was the tenant of the premises in which the partnership business was carried out. So it says, now I'm not assigning my tenancy rights, I'm just leaving the firm. So the partnership business might not come to an end, the business still can continue to remain in the same favor. All right, children. And those who were specifically talking about section 23 and 24, I hope now it is specifically clear to you. Simply where it is written, children, admission of a partner means you have to write down acts done by a partner, rule of the firm becomes liable. And notice to the acting partner means if the firm, any one of the partners is having the knowledge about any action taken by one of the partners, it is assumed that whole of the firm is having the knowledge about that. Another important question that we'll be taking from examination today is liability to third parties. So please remember, there are three different kinds of liabilities, section 25, 26, 27. Here it says liability of a partner for acts of the firm. So if examiner asks you what is the liability of a partner, so any acts done by the firm, all of the partners become unlimitedly liable. So unlimited liability arises in case of any actions of the firm taken. Do you think that the firm is also liable for any action of the partner? Definitely. Any partner does any wrongful act, then also the firm stands liable for that, provided it is done in the ordinary course of business and with the authority of the partners. This is what we understand in section 26. So section 25 says partners are liable for the firm. Section 26 says firm is also liable for any action of the partner. And third, again, it is talking about the firm's liability. So it says any misapplication done by a partner. Remember that example of car? A partner by mistake sold the car of someone else. So you have misapplied the property of a stranger. You have received the money by misappropriation of the funds. Therefore, now firm stands liable. Whole of the firm become liable for your action. So if any examiner asks you about the questions, which we'll be just discussing in a question paper, that what is the liability of the partners and firm, you specifically have to mention about these three sections. Section 29, I told you that a partner may transfer his interest in the firm, either absolute or by mortgage. Or I just want to transfer my interest, or by way of mortgage, I'm transferring my interest. But during the continuation of the business, that transferee does not get the right to inspect my books of accounts. So what are the rights of the transferee? A, B, C, 3 members in the firm. A decides to transfer 50% of his share of profits to Mr. D. So section 29 says now this Mr. D becomes transferee. What were the rights which were given to this transferee? Number one, he will get the 50% share of profits, that if the firm has declared the profits, whatever is the share of Mr. A, 50% of A's share will be given to Mr. D. Can he inspect the books of accounts? Law says no, transferee Mr. D cannot inspect the books of accounts. What happens if the firm is dissolved, or if this Mr. A ceases to be a partner? In that very case, it says if the firm comes to an end, then Mr. D gets the right to inspect the books of accounts also, and he also gets the rights. He's entitled to all the assets of the original partner. So let us first take this. I have 2 question papers for you, July 21 and January 21 paper. And there is one question paper which has specifically, it is talking about this application of section 29, which I asked you specifically to remind me, and you have reminded me very nicely. So good, let's do this question paper first, children, and then we will proceed further. So now you are going to answer me when I ask you about this particular question paper. So I hope you all can see this 2021 examination question paper in front of your eyes. So the best part is the institute has updated the site in such a way that everything is just available at a click of button. So you all are blessed students, children, that you can even study the recent question paper that has come. It is updated along with the suggested answers on the website. So you simply have to just go through it, learn it, revise. So now let us first see what are the questions that come from the Indian Partnership Act. So first question number 1 is generally from your Contract Act, your Companies Act, and one we have done is from Sale of Goods. So question number 1 does not have anything in partnership. Question number 2 also has nothing to do with your partnership. A general trend is LLP question, which is coming from last 5 years. For 5 marks, LLP question comes, which is generally a part of question number 2, part B. Now, the trend that has been following, the first question that comes from Indian Partnership Act is question number 3A. So if you're writing down, you're making notes, please write down question number 3. Question number 3, part A, 6 marks question is generally of Indian Partnership Act. What is it talking about? Simple, define implied authority. In the absence of any trade and customer, do you think implied authority does not empower him to do certain acts? So quickly tell me what will be the answer in this question. It says state the acts which are beyond the implied authority of a partner. Can you just name the section which will become applicable without cheating the answer? Can you tell me? Arjun and Dhruv Khandelwal are asking now, what is expulsion of partner? Expulsion means when you are removing a partner from the firm. And if you have not attended the previous lecture, you can go to the recorded lecture. In the previous session, we have in detail talked about expulsion. Yes, Parth, you can call it a novation of contract because that is also the replacement of the contract that happens. But that is a different context in which novation takes place. Here we are talking about the change in the constitution. Vanshika Gupta, we just discussed section 14, partnership property. So I hope your point also got clear. So what will be your, which section will become applicable over here? Tell me. Manisha Tehlani, the first one to answer. Excellent. Dinesh, Balakshmi, very good all of you. So Parth, you simply need to go to the ICAI website and you can download it from the links that are given for mock test papers, suggested papers. Everything is available there. Excellent. Section 19 to 22, which typically talks about your restrictions on the implied authority. Now, what the examiner has asked you, he's specifically talking about section 19, all those restrictions which I taught you. You can either write it in your own words or you can just write the replication of the answer given in your study material. So if you'll simply see where we are trying to restrict, so you can tell the examiner that although the partner, whatever action is taken by him, it binds the firm, which I told you in subject to section 22, and there are certain authority of the partners which is restricted. So these are the specific cases, 7-8 cases where the partner does not have the authority to do such acts. Simple, you get 6 marks if you have written the answer beautifully in the same points. Question number 3, part 1 is from Partnership Act, 6 marks. Let us find another question which comes for 6 marks from partnership. That is question number 4, part B. Question number 3, part A, 6 marks from partnership. Another 6 marks question which comes from partnership is question number 4, part B, is generally from partnership. So it says M is one of the partners. And now your section 29 is going to come. Please pay full attention. Those who have been repetitively asking for the descriptive case study, please pay attention. Yes, Mr. Sonu Shaw, Pushpa, Hira, Jyoti, all of you are correct. Good. Arbitration basically means where you're not going to the lawyer and you have appointed an arbitrator for settling the disputes of this question. Nikhil, trade and custom means if you have a general, you have a custom, you're following a rivaz hai. Aapki firm mein jaise interest on capital, we have been giving it. We have been following that routine nature. Then whenever a new partner is also coming, we follow that kind of custom. So trade and custom means the something which you have been following from long time period. All right. Yes, Mohammed Ahmed, you're absolutely correct for that answer. All right, children, now pay attention. Mr. M is one of the partners. He owes a sum of rupees 6 crore to his friend, Mr. Z, which he is unable to pay on due time. Now, this is the same example which I was telling you the other day on section 29. That is, I have taken a loan from someone and now since I want to repay my loan to that person, so I decided that I will sell my share of the property in the firm to that person for settling my amount. Are you understanding? He said Z is a person. So who are the 4 partners? Mr. M is one of the 4 partners in XY Enterprises. He's not telling you the name of other partners. He simply told you that Mr. M is one of the partners. Who is Mr. Z? Mr. Z is a third person. He's another person from whom he has taken a loan. Now M could not repay the loan. So he transferred his share in the firm to Mr. Z. So can we say that Mr. Z is a transferee? Is it correct? Very nice. Those who have written, yes, ma'am, Mr. Z becomes transferee. Definitely, Jyoti Jha, M can transfer his share of profits as per section 29. So first it is asking you, can Mr. M transfer his share in the firm by way of sale? You simply have to write the provisions of section 29. Yes, transfer of share is allowed. The only case you have to remember is what are the rights that the transferee Mr. Z is entitled? Mr. Z is entitled to the share of profits that has been agreed. Number 2, Mr. Z cannot inspect the books of accounts. Simple. Whatever profits we are giving to him, he quietly has to sit and relax and eat those profits. He cannot interfere. He cannot check the books of accounts. And what is the second case? Second case, he is typically asking you about section 29. Subsection 2. It says if the rights of transferee Mr. Z, if M wants to retire after 6 months, then what happened? So what will happen now? Tell me, give me the answer for B part, second part. I want the answer from all the students. Very good. Neelam, Jaspreet, Harshita, Vidya, Chandan, Priyanka, those who are giving the correct answers. Excellent. So this is your exact application of examination question paper where you're applying section 29. So can you tell me what will happen? What were the rights of Mr. Z if Mr. M, the original partner, now he's retiring from the firm? So he's leaving the firm. What will happen? Let me see your answers before we read the answers from the suggested ones. Absolutely correct, Chandan. Z will become transferee. Harshita is also correct. Give me the answer for the second part now, quickly. Absolutely correct, ma'am. Now he can interfere in the books of accounts. He get entitled to all the assets of the original partner, as well as he will be entitled to inspect the books of accounts as well. Definitely, that's absolutely correct. Bhumika, Manisha Tehlani, Karishma, Manisha, you had a query in section 29 and you're answering. So that's great. Shivam Chaudhary, Vanshika Gupta, Priyanka, all of you absolutely correct. So now let us quickly see how you have to write the answer. First of all, you will give the concern provision, section 29. Ma'am, this is what section 29, subsection 1 and subsection 2 says. Simple. Now let's apply. In the light of the facts means now we are going to apply the law. So question number 1, yes, M can transfer his interest. This is what you people have already answered to me. Second, on retirement, now yes, section 29, subsection 2 will become applicable. It will say that the transferee has the right to receive the share of the profits and also he will be entitled to the shares what the original partner was entitled to. So he is entitled to an account from the date of dissolution, means now he can inspect the books of accounts. You can write in your own language, children. See, he is giving you the entitlement of the rights over here, na? That he is entitled to receipts and for the purposes of ascertain that share, he can also access the accounts. Iska matlab kya hai? Ki finding out now, he can interfere with your accounts. Are you giving me the correct money or not? Ascertaining that share means for finding out his share. Ascertaining ka matlab likh lena. For finding out his share of profits, whatever you're giving, he can have an access to your account. So now he can have an access to your books of accounts. In my presentation notes, I have written in a summarized form, so you can read it from that section 29. So that means now M's retirement, Z would be entitled to receive the value of Mr. M to the extent of rupees 6 crore in the firm's assets. So all of the assets of Mr. rupees 6 crore, he become entitled to receive that as well. Clear ho gaya? 6 marks question, implied authority. You all knew that answer. Done. 6 marks, another question. Done. 12 marks from Indian partnership. We have done. Now another question of 4 marks, which generally come from Indian Partnership Act, is the last question, which generally comes in the part of 2 marks or 2 marks, or it is in the form of direct 4 marks question. Now, this is the question which my students are going to understand in today's presentation. It says, what are the rules to be observed in settling the accounts of the firm after dissolution? So again, a straightforward question number from section 48 has come in the exam. And what you have to write the simple paragraph, the mode of settlement of the accounts. So this is what we're going to do in today's presentation as well. So I hope all your queries have been very well justified and answered. And we have discussed one of the important question paper also. So I'm glad you have learned how to write the descriptive question paper also. Thank you so much. Those who have written, ma'am, very well understood. Great. I'm glad to know that. All right. So now the topics that we are going to cover are, first of all, we'll be discussing today about the registration of the firm. So the 2 halves of the classes, one is about registration of the firm. Second is about the dissolution of the firm. Now, children, do you think, is it important to get the firm registered? It says it is not compulsory for the under the Indian Partnership Act to register the firm. So under the Companies Act, it is must. Under LLP, it is must to have its registration. But do you think partnership firm, is it compulsory to get it registered? The answer is no. So number 1, registration of firm is not compulsory. But there are certain benefits which are given under section 69 to the firm which is registered. What did I say? There are certain benefits, there are certain advantages, there are certain rights under section 69 which are given to a firm, only the firm which is a registered firm. Now it says state government has the power under section 57 to appoint the registrar for the particular states, and simply you have to understand under section 57, 58 and 59 what is the modes of effecting registration, means what is the method if you want to get your firm registered. So first of all, we'll be understanding what is the method of registering the firm, what is the meaning of registering of the firm, and what happens if a firm is not registered. After that, we'll be covering the topic about the dissolution, which generally you know the meaning, how to wind up, how to close the firm. So section 58 talks about the registration of firms. So simply, children, for getting the firm registered, what you have to need to do is you have to make an application to the registrar. You need to file an application. Section 58 simply tells you a statement. So when we use the word statement, statement means an application which needs to be filed in the prescribed form, stating following documents which need to be filed with the registrar of firms. So we can use the abbreviation like ROF. So ROF means the registrar of firms. So firm wants to get itself registered with registrar of firms. They need to simply file an application. So statement means an application needs to be submitted. So tomorrow, if I am setting up a firm, say Harleen and Shivam Associates. So if we are setting up a firm and we thought, let's get a registration done. So Harleen and Shivam will need to file an application. They need to go to the registrar of firms. And what are the documents that they need to submit along with this application? These are the documents which we should file. What that statement, what that application is going to contain. It will tell the name of the firm, that is Harleen and Shivam Associates. Where is the place of business? Are we doing the business in Delhi? Are we doing the business in Bombay? Where is the place where we're doing the business? So it says every state government has set up their own registrar of firms, and with whichever state you're setting up the firm, you need to go to the registrar of that particular area. So if you're setting the firm in Delhi, you need to go to the Delhi registrar of firms and need to file your application. So you have to tell them the principal place of business, that this is the place where I will be doing my business. Name of the place where the business are carried out. Now, place of business, what is the place where we getting the business, and what is the name of the business which we are going to carry out. So if we're carrying the business, we are the cloth merchants, we'll mention that name. If we are into electronic business, so what is my business along with the place of business? I also need to give the nature of my business, which we have decided to carry. Date when the partners joined the firm. So Harleen and Shivam Associates is getting itself registered. Now, when Harleen joined the firm, when Shivam joined the firm, say for example, Mr. C has also now joined the firm. So what is the date on which Mr. C has joined the firm? So whatever dates when the partners are joining the firm, it is very important to mention such dates in your registration form. Say for example, you got your firm registered. So Harleen, Shivam and Mr. C, they have already mentioned their date of joining and we have received a registration certificate. After an year, Mr. D also joined the firm. Don't you think I need to obtain a fresh registration certificate? Law says definitely you have to include Mr. D's name also now. Now you have to tell him that one of the partner, Mr. D, is also registered in the firm. So today we'll be doing a very interesting question from the study material given on your second page of your study material of this chapter, which tells you that if you have not obtained the fresh registration, then you cannot take an action against the third party. So if your firm is registered, ABC Associates are registered, and A is taking an action, that is absolutely fine. But if another partner, number 4D, is admitted in a firm, then ABCD, fresh registration has to be taken in order to take any action against the third party. All right. So it says what are the date when the partners has joined the firm is very important to mention to the registrar. Full name of the partners and their addresses. So you have to write what is the name of the partners, Mr. C, Kapoor, Mr. D, Raghav, whatever is the name of the partners, full name has to be given, and where do they stay, what is their address, everything has to be filed with the registrar of firms. And what is the meaning of duration of partnership? You have to tell me what is the meaning of duration of partnership. If I say the partnership is for 10 years, then it becomes fixed partnership. If I say the partnership is for particular period, then it becomes particular partnership. All right. So all these rights, definitely Priyanka, section 69 give them the certain rights. Thank you, Mayur. I really feel blessed to have such kind of beautiful comments from your side. Thank you, Lakshmi. All right. So duration of partnership, very well written. Those who have written, ma'am, it can be a fixed partnership, or it can be a, what do you call that? Particular partnership, or it can be a partnership at will. What is the meaning of partnership at will? That means partnership as at our own sweet choice. And how does the partnership at will comes to an end? Can anyone tell me? Okay, let me take your quick test. I said duration of partnership. It says that duration of partnership can be for fixed term. It is a fixed partnership. If it is for particular event or particular adventure, it is a particular partnership. When I say partnership at will, what is the meaning of partnership at will? It means today, me and Raghav, we decided to be partners, but we did not decide for how long. We did not decide for how much period. So we have not determined the relationship of partnership will be for how long. Now, what does it mean? It means that this is the partnership at will. When the period is not fixed. Excellent, Mohammed, Shiv Tripathi, Vanshika, Manisha, Yajit Sen, Vidya. Definitely. Very good, Vidya. Vidya is the first one to answer. By giving a notice in writing, partnership at will comes to an end. Very good. Very nice, children. Jaspreet, Jyoti, Manitha, Sarthak Agarwal, Jayanti. Very nice. So all of you are correct. Vanshika. So by giving a notice in writing, partnership as well as for indefined duration, we have not fixed whether we decide to continue till evening, we'll continue till evening. If we want, we can continue the partnership for ages. But the only way to wind it up is by giving a notice in writing. Good. So all these documents, section 58 simply talks about that the statement and application needs to file with the registrar of firms, and all these documents need to be filed along with that. Now, what does section 59 says? Before coming to an end to section 58, it is also written in your study material. Please refer. It says registration of partnership is optional. So please mark it down. Registration of partnership is optional. That means it is not compulsory to get your firm registered. Even if you're not registered, it is absolutely fine. Very good, Shambhi, Siddhi, Dinesh. I'm not reading the names now. Good children, you all have answered correct. Harshika, Aditya, Arjun, Chetan, very nice. Okay, so analysis of section 58, if you'll read in the study material, it is given, it is optional, it is not compulsory. One partner cannot compel another partner to join in the registration. So consent of all the partners is compulsory. You cannot compel means you cannot force the partners. So it is not essential the firm should be registered from the very beginning. Now, this is very, very interesting. So children, if I tell you that I opened up the firm in February 2021 and ABC Associates opened up the firm in February 2021 and it was an unregistered firm. In March 2021, they thought that let's take a registration certificate. So is it valid? I opened the form in February 2021 and it was not registered. Can I obtain my registration on March or maybe April or any other month? So law says, yes, the partners can decide to get themselves registered anytime. It is not compulsory that the registration has to be taken from the very beginning. So even if I decide to get myself registered in December 21, then also it is valid. But then it will be registered firm from December 21, not from the previous date. So you can decide to get yourself registered anytime, even after opening of the firm. So this is what section 58 tells you. The only requirement is you need to file all the documents with the registrar of firms. And what happened under section 59? If the registrar is satisfied that all section 58 has been complied, then he will make an entry in the register. What entry he will make? He will make an entry that ABC Associates is a partnership firm and we shall file this statement. So this is his routine task of nature. It says recording of an entry is a routine duty of registrar. So after he is satisfied that all the points have been confirmed, everything is valid, he will record, he will make an entry that this firm is absolutely ready to get itself registered. And that is how he will issue a registration certificate. Now it becomes a legal entity since it is a registered firm. Legal entity means now the partners can take an action. Now they can take an action for the settlement of accounts. They can take an action against the third party also. So section 969 specifically gives you a lot of rights are available if the firm is registered. So what have we learned in these 2 points? Number one, it says registration is not compulsory. So we can just summarize it down. So registration is not compulsory for partnership. Very well understood. It is not compulsory. But if registered, we get certain benefits under section 69. So this is the short form of writing under section. And mode of registration, how the registration needs to be done is given under section 58 and 59, which we just read. What are the terms that you also have to be careful that in the firm's name, you should not be using the word like crown, emperor, imperial, king, queen. So law says this is strictly prohibited. You cannot have such kind of names. And if you're having such kind of names like approval or patronage of government, then a state government approval is required, and that approval should be taken in writing. So this is another important point while you're filing a statement under section 58. Please remember that the firm's name should not contain such kind of words which are given in the paragraph in the study material. And also it should not be the name which the firm is already registered. It has to be a different kind of name for your own particular specific firm. And once registrar is satisfied that everything has been complied, everything is in place, under section 59, he will make an entry in the register of firms and he will issue a registration of certificate. So this is the small paragraph that is written. This is the summary of what we have just discussed right now. All right. So this is how your registration certificate basically looks like, that if any partnership firm has obtained a registration certificate, now they have to keep this at the place of business. That means section 69 give them the rights because it is a registered firm. And 24th February 2015, if you can just read, the date is written from which the registration certificate has become valid. So date is also important in the registration certificate. It is also mentioning the name of the business. Cargo Pack is the name of the business, where it is a registered office. Everything has to be mentioned in your registration certificate, and even the name of the act. Can you see Indian Partnership Act 1932? This is also mentioned. So registration gets complete. Your compliance work is given under 58, recording of statement section 59, and then the registration as certificate is given. Firm and company registration. So that means thappa lag gaya. Now it becomes a legal form. So a stamp is given you of a register. So now benefits are given in a negative statement. It says, what are the consequences of non-registration? Means if your firm is not registered, then what happens? Again, very, very interesting point. So please listen carefully. It seems very easy, but you have to pay full attention in order to understand it. It says no suit in a civil court can be filed by a firm or other co-partners against a third party. Now, what does it say? Law says if your firm is not registered, then you cannot take an action against the third parties. Now, why do you need to take an action? Say, for example, ABC Associates is a partnership firm and they are doing very good business with a dealer, Mr. D. But once Mr. D failed to give them the payments, now the firm is very angry. ABC partners felt very angry. They said, we'll take you to the court. But they were not registered. So if the firm is not registered, can they file a case in the court against Mr. D, the dealer? Yes, ma'am, or no, ma'am? I just gave you an example. Sunil Yadav, I hope your point is clear now. Children, in between, you keep asking queries also. First, you answer me, okay? Okay, Jagruti. It again depends upon the screen share that we have done. Accordingly, the Zoom gives you the tell me yes or no. Yes, children. I'm waiting for the answer. Can we say that firm can take an action in the court against? Definitely, no, the firm cannot take an action. And Ms. Bhumika is absolutely right with the reason she has given. Because the firm is not registered, we can take an action. Mr. Piyush, R.N. Agarwal, Karma, Pooja, Sridhar, Aditya, Pooja Swami, Sarthak, Lakshmi, all of you are correct. Oh, wow, excellent. Many of you have answered. Karishma, Manisha, Dhruv, Shiv Tripathi, Meher. Dipanshi, Sanyam Jain, Pushpa, that's absolutely correct. You cannot take an action against the third party if your firm is not registered. So we have just understood with the help of example also. So please write down this particular example in your notebooks that the firm cannot take an action. And if I would have been a registered firm, then yes, definitely I could have taken an action against the third party. Point number 2, it says no relief to the partners for set off of claim is available. So it says, for example, I had to pay you certain money, say rupees 8,000, and you had to pay me rupees 2,000. So can we say that I can just set off the claim 8,000 minus 2,000 and I just pay you 6,000? So law says if your firm is not registered, then such set off of claim is not allowed. Only till what it is allowed? It is only allowed till rupees 100. Children, I hope you can see the class now. I think some error came in between. Mr. Surya Kumar, Vanshika, Subhash, Jaspreet, Arjun, Anand Dubey, all of your answer is correct. Vidhi, Arjun Sharma, Parth, Dinesh, Ruchi Bajaj, Vidya, Mr. Abdul, your answer is correct. Miss Siddhi, Chandan, all of you, H. Om Prasad. Children, I hope my voice is audible. Please just send me a confirmation. I hope now it's clear. It got stuck for a second in between. That's correct, Sarvesh. All right, so no relief is available to the partners. So only exception is up to which amount the relief is available. Up till rupees 100, the relief is allowed, which is just a nominal amount, which hardly happens. Have you ever seen any partnership firm? Up till rupees 100, its set off is allowed. So if I have to pay you 4,000 rupees and you have to pay me 4,100, so 100 knocking off can be done. The rest has to be paid off. So it says the only exemption is cancellation of amount up till rupees 100 is allowed. But if the firm is not registered, you cannot claim the set off of the balance amount. All right. Aggrieved partner cannot take an action against another partner. Now, this is also very interesting. Number 1, we cannot take an action against the third party. Also, the partners cannot take an action against each other. Now, let's assume there is a firm PQR Associates. And Mr. P and Q are not having good relationships with each other. They're always fighting. They're not even having a relationship of trust and faith. Thank you so much for confirming, Bhumika, Surya Kumar, Jagruti, all of you. Thank you, children. Okay, so it says, Shabhambi is saying 100% clear. Good. Thank you, Jatin Mahesh. So aggrieved partner, it means if P and Q are not having cordial relationships with each other and they're fighting and now they don't want to continue with the firm. So can they take up any action against each other? Law says if your firm is not registered, so I'm sorry, you cannot take up any action against each other in the court. Only the registered firm has a right to take the action. But the only exception is in the case of dissolution of the firm. The only exception is in case of any criminal cases. So if any crime has been committed, Mr. P has, killed someone. So now it is a criminal case. So now, obviously, police will take an action against you, not only just the partners. So it says the only exception is other than the criminal cases. Otherwise, on routine nature, you cannot file a case against each other if your firm is not registered. However, in the case of dissolution of the firm, say for example, Mr. R is retiring and his share of profits are not given and the firm is getting dissolved, then R can still take up action in the court for the settlement of his account. And the last part is third party can still sue the firm. Now, the previous example wherein I asked you that ABC Associates is a partnership firm and they could not take an action against Mr. D. Very right. You all answered me, yes, ma'am. They cannot take an action against Mr. D because the firm is not registered. Can Mr. D take an action against ABC Associates firm even if the firm is not registered? Yes, ma'am. I know you all are going to give me the correct answer. Third party can still file a case against you. So if ABC Associates have not paid the money to the third party, Mr. D can straight away drag you to the court even if you're not registered for. So that is the benefit for the registration. I can file a case against Mr. D only if I'm registered. But the only exception is third party can still file a case against me even if my firm is not registered. All right. So let's just take up certain exceptions from the study material as well, because I really don't want you to leave a single point over here. So let's go to the study material also once. I think children, let's take a small break over here for 5 minutes. I will go through your queries also, and then we'll begin from the study material. We will read the exceptions which is given under the following rights. All right. All right, all right. All right, welcome back, students. Let's continue. I was just going through your queries meanwhile. And thank you, Pushpa. That's really very nice of you. Thank you. I'm glad you're understanding each thing very nicely. So many of you have sent the answers. In between, I have to find your queries. Yes, definitely, Aditya Sinha, all the partners should give their concern for registration. That's correct. Shiv Tripathi is asking if we are not registered firm. So simply you have to remember, if the firm is not registered, the 4 points that we just discussed under section 69 will become applicable. Sanyam Jain, these words, I think you are talking about the names which are excluded. So that is the comprehensive list of the names that is excluded from the firm's name. That is something which you have to remember as it is, because imperial, king, queen, royal, these are, associated with certain patronage of government. So you have a queen in UK, you have a government in India. So you cannot have these kind of where government approvals are related, government is involved, something related to your country is involved. You cannot use these kind of words in your partnership form. All right, Sanyam. Partner can file against the case, Priyanka. That's absolutely correct. If ma'am, it's needed to renew it without admission. Karishma, your query is not clear. What are you asking? You can write it again. Third parties can sue the firm based, Priyanka. That's correct. Definitely. I think this is what you have been answering me. What is the meaning of precluded? Lakshmi, we'll understand once we'll open from the study material. I'll explain you how the things get precluded from a particular content. Thank you, Dipanshi Agarwal. I'm glad you enjoy the class. All right, Aditya Sinha, we can ask the institute and I'll update you on the same, the query that you have just raised. Okay, unregistered firm. Nikhil, regarding your income tax benefits, what happens under the ITO when you go to the income tax officer, what exemptions are available? That is a different story. We are not going into detail about your tax exemptions as of now, all right? Definitely, Ms. Hira Hussain, late registration has a penalty of a nominal amount of ₹100. That will also be, just understand that as well. What is the time limit for the registration? Priyanka, the time limit that has been given for the registration, first of all, you have to understand it is not compulsory to get yourself registered. All right. So if you have decided to get yourself registered even after a year's time or wherever all the partners consent, then also it will be justified. Okay, so let's just take it up from here as well. Definitely, Manisha, we'll try to do that as well. Mr. H. Om Prasad, that's absolutely clear. You must first try to cover the study material and do the MCQs, whatever we have discussed in the class, and then you should jump to your mock test papers. Otherwise, you'll not understand what the mock test papers are talking about. Okay, so first try to complete the syllabus. Ms. Bhumika, the point of relief and set off, we'll just try to cover from the study material also once again. Thank you, Saloni Goel. Dhruv Khandelwal, I have seen one company named Crown and it is registered. So one person company is again a different story. When I teach you about Companies Act, we will discuss it there, okay? All right. So now let's come to here in your study material, section 58. This is what we have just discussed, how the application needs to be made, what are the contents, and this is your note that we were talking about, that you cannot use such words unless you have taken the approval of the state government. So it says Crown, Emperor, Empress, include kar sakte ho, but then state government's approval has to be taken in writing. Generally, you cannot use these words because they are related to your patronage or approval or sanction of the government is required. So if state government has given you in writing the approval, okay, fine, you can use the word impress, then you can use these kind of words. So where somebody was asking, ma'am, there is a firm which is registered, so they must have taken the approval of state. This is what you have understood. It is optional, not compulsory. Section 58, subsequent alterations, very, very important line. Please mark it, very important. Sometimes students, there is a hidden statement which you need to understand what is it trying to tell you. So what is the meaning of subsequent alterations? Any name of the business is changing, any place of the business. So we thought that we will be dealing in the shoe business. Now we are going to change the business into electronic business. So we thought this COVID era has been a tech savvy for all of us. So electronics, gadgets is something which is really coming up and having a good market. So we thought that let's wind up the earlier business and now let's change the business only. So any name of business, place or constitution of business is getting expanded or changed, then such changes have to be registered with the firm. You cannot say that I was registered with the firm ABC Associates for a shoe business and now I've changed it into electronic gadgets business and I did not get myself registered. You have to update the registrar of firms. You have to get that name striked off and get a new name of the firm registered, because an entry is recorded in the registrar of firms. So you have to, such kind of alterations means such kind of changes needs to get themselves registered. And also the constitution of the firm is changing. Any partner is joining the firm, any partner is retiring, such kind of details needs to be updated with the registrar of firms. Section 59 also, my children have clearly understood that when the registrar is satisfied, he will issue a registration certificate, he will make an entry in the registrar of firms, and this recording of an entry is a routine duty of the registrar. Registration may also be effected even after suit has been filed by the firm, but in that case, it is necessary to withdraw the suit first and get the firm registered and then file a fresh suit. Now, when ABC Associates got angry, who all told me that they cannot take an action against Mr. D? Yes, they cannot take an action. But law says they can anyways get themselves registered then in that very time, and then they can file a fresh suit. They can take a fresh action. Now, those who were asking me about the penalty, Section 58(1)(a) simply says, it says if the statement is not sent or delivered within the time mentioned under 58(1)(a. Now, 58(1)(a) is silent over. So it says once your registration things are going on and you have not submitted the application, the things are not submitted to the registrar, then a simple penalty of 100 rupees per year of delay on your part is charged. So it's a very nominal kind of penalty that you simply have to remember. This is the latest amendment that has come up. It says late registration, any late if the statement is not sent or delivered. So we have decided to send or delivered it in the respective time. You have not filed it, then a rupees 100 penalty is charged for that delay. In case of failure, so again, this is talking about the analysis of 59(1)(a). This is what we just discussed, section 69. Now let's talk about following exceptions. Now again, children, these exceptions are coming from the above statements only. It says, what are the exceptions? What happens if the firm is not registered? Right of third party to sue the firm. You can still, third party can still take an action against us. What happened regarding your 100 rupees? We have already discussed the right to claim a set off for rupees 100. It's still allowed. Power of the partners to sue for the dissolution or settlement of accounts. So I told you, although the partners cannot take an action against each other, but for realization of the property, for settlement of the accounts, you can still take up an action even if it is an unregistered firm. Power of the official assignee or receiver of court to release the property of the insolvent partners. Now what happens? I told you if a partner is declared insolvent, then his entire property lies with the official assignee or official receiver. He will sell off those assets of the insolvent partner and pay the liabilities. Now, law says even if your firm is not registered, you cannot take the rights of the official assignee. He is appointed by the court to realize your assets and pay off your liabilities. His rights are still available even if the firm is not registered. So let us take an example. There is a firm ABC Associates, which is an unregistered firm. Mr. B became insolvent. Now the property of Mr. B will be lying. The court will appoint an official assignee and he will take care of all the property of Mr. C and will pay off the liabilities, even if the firm is not registered. A right to sue instituted by legal representatives or heirs of the deceased partner for the accounts to realize the property. Now this is again very, very important. I told you in case of a death of a partner, if the debt is arising later on, the legal representatives are not liable. However, the legal representative have the right to file a suit in order to get the payment of the deceased partner, settlement of accounts, section 35, 36, 37, we understood. If any subsequent profits you are making, you have to pay me the subsequent profits also if using my property. And section 35 typically talks if the partner has died, legal representative can still file an action in order to get the payment of the accounts. For any accounts of the firm for realization of the property of the firm, the right to suit and proceedings by the legal representative is still held valid even if the firm is not registered. Means ABC Associates was the firm, Mr. A died. Now legal representative of Mr. A can still take up an action against the firm for their settlement of the accounts. Now, this example number 1 is very, very important, children. I somehow have an intuition that this kind of question is once going to come in your exam also. So let's pay attention. It is a self-explanatory case study given in the study material itself. It says A and company. Now, you will not read the answers like honest students. You will not read the answers and you will give me the answers. Okay? So Sarvesh, set off of claim means the partners say, for example, I have to pay you 5,000 rupees and you have to pay me 2,000 rupees. So I can just set it off now. 5,000 minus 2,000, you will say, okay, ma'am, you only pay me 3,000. But law says if my firm is not registered, I cannot do this set off. Means I have to pay you full 5,000 and whenever you pay me 2,000, that is a separate story. I have to complete my payments. I cannot do the knocking off of the entries. Shiv Tripathi, the notes are already uploaded on the ICAI portal where you send me the queries. There is on the left hand side, you will download the PDF. So you can download the notes from there. Arjun Sharma, partnership was earlier part of Indian Contract Act. So it began from the Indian Contract Act 1872 provisions. And after that, a separate Act 1932 was formed. It has actually come out from your Indian Contract Act itself. Definitely, Mr. Abdul, that's correct. All right. So here comes your question. So which you all have to answer me. A and company is registered as a partnership firm in 2017 with how many partners? A, B and C are the partners. In 2018, children, A died. So in 2017, the firm is a registered firm. Please read the words very carefully. It is a registered firm. 3 partners were there. One of the partners has died. Now B and C filed a case against X. Who is X over here? Can you tell me who is X? X is a third party. So there is a dealer with whom the firm has been dealing and law says now B and C are going to file a case against Mr. X in the name of A and K without fresh registration. Now what is happening over here? They're giving you a very interesting story. They said A, B, C were 3 partners and the name of the firm was A and Company. And now A has died. And look at this, Mr. B and C, they are filing a case against Mr. X. Number 1, can they file a case against Mr. X? Yes, ma'am, it is a registered firm. Therefore, they can file a case against Mr. X. But children, I have a certain doubt that they're filing the case on behalf of A and Company without fresh registration. Do you think they need to get themselves registered first and then file a case? Give me a valid answer. Do you think they need to get themselves registered? Vanshika Gupta, it is given in your study material. Yes, Priyanka, that's absolutely right. They can file a case. But my question is, don't you think a fresh registration is required or they can file a case in the name of A and Company only? So it's fine, Vanshika Gupta. You can simply read the analysis of what is given under the study material of the sections, and you can refer to the notes that I shared with you, and you can read it from that. Oh my God, who is this? Somebody has written, please take my name also. But what is your name? It is not appearing. Lakshmi, is it you? Are you writing this, Lakshmi? No, because the subsequent change in partnership should be registered. Miss Manisha, your answer is wrong. Jaspreet is talking right. What does sue mean? Sue means filing a case. Bal Lakshmi, sue means filing a case. We are talking about filing a case. You have to know the general words of the law, literal meaning by now, children. Sujal Gupta is saying, yes, ma'am, they need to get registered. No, that's incorrect. Vanshika Gupta, no, he is not. Chetan is saying yes, yes, ma'am, no, ma'am. Saloni Goyal is saying both the answers. Harshika says B and C, they can file a suit. No need to notify the registrar. Harshika Singla, absolutely correct. So this is the kind way I want the answers, children. All of you have given the correct answer. Khushi, Vashni, Mansi, Akshni, Sunil, Pooja Swami, Piyush, Ruchi, Abdul, Sabreen, that's correct. No, Sabreen, that's not correct. Pushpa is correct. Aditya, Abhigupta, Arjun. Now listen carefully, children. Okay. So children, why fresh registration is not required? Now pay attention. I told you A, B and C, they were already registered with the name of A and company. A died. So B and C are already registered with the name of A and company. They can still file a case and no fresh registration is required. Have you understood? First of all, please, by now you should know the meaning of whether a suit is maintainable. Kai bachche yahi पूछते जा रहे हैं, ma'am, what is the meaning of filing a suit? Filing a suit means filing a case. You're studying law, children. Now don't do such kind of things. Filing a suit means filing a case. We are discussing whether you can file a case or not. So here you can file a case. A suit can be filed by the remaining partners without notifying the registrar of firms. Why? Because one of the partner has just died. Other partners are still there. Remaining partners can sue in respect of subsequent dealing, even if fresh registration has not been obtained. No notice was given to the registrar, then also it's absolutely fine because the other partners are still dealing with the firm. So it says the suit may be filed by the firm and the person suing are still registered. Therefore, action taken by B and C against X is highly maintainable, means yes, they can do it. Now there is a twist in the story. It says if B and C have hired a new partner, Mr. D, then children, do you think a fresh registration is required? The answer is yes, ma'am, because now we need to introduce the name of Mr. D also in the record with the registrar of firms. Now it is to be notified to the registrar to make a record of notice in the entry relating to the firm that one of the new partner has been introduced. Therefore, now firm cannot sue as D's new partner has not been entered. In the second requirement, person suing means jo banda case file kar raha hai. Person suing means the person who is filing a case or filing an action against the other party. His name must be appearing in the register as a partners, and they all must be partners on the date of suit. Understood? So if one partner is leaving you, no need to file a fresh registration. But if a new partner has joined, then a fresh registration is compulsory for the firm. All right, children. So I will be coming to the MCQs later on because otherwise we'll be left with the syllabus. Let us first complete the syllabus. So registration, I hope we have done it very nicely, clearly. Now let's move to the dissolution. So we had a nice partnership among each other. We were finding a bond of good relationship. Now we have decided to break this wall. Can you see the wall which is breaking, the floor which has broken out in between? Everybody has started pointing them. Everything has turned black and white. That means now we have decided to discontinue the partnership between us. We no longer want to be with each other. Somebody is holding his head. Somebody is giving different kind of expressions. Ladai ho rahi hai, jhagda ho raha hai. They are not happy. They're not satisfied with each one. They have decided to stop the partnership business. This is what we understand with the word dissolution of firm. Dissolution of firm means now we want to discontinue the partnership that we have decided to form between the partners. So dissolution of firm is different from dissolution of partnership. What is dissolution of partnership? Dissolution of partnership, that 3 partners were earlier there, 1 has left to continue the firm. 4 partners were already there, 1 partner joined, 5 partners are now doing the business. So what will happen? 4 partners will dissolve the partnership and they will form a new partnership with the 5 partners. So in dissolution of partnership, we're just changing the constitution. We're not affecting the continuation of the business. We are only doing the reconstitution of the firm. The firm is reconstituted with new names. However, dissolution of firm is absolute end. Remember this picture of black and white which I've shown you over here. We're just pinpointing, we are blaming, we are not happy, we are not satisfied. Ab hum aapke saath kaam nahi karenge. Simple, we are closing the business. We don't have any other alternative. So dissolution of firm is a broader term with respect to dissolution of partnership. Dissolution of firm means everything is coming to an end. Now we are going to close the business with you. No longer this firm is going to exist and everything is going to end up. That is the meaning of dissolution of firm. So very nice. I want to tell you over here, there is a difference between dissolution of partnership versus dissolution of firm. Where I'm just reconstituting the firm, I'm doing dissolution of partnership. Where I've just turned my face the other side, I no longer want to do business with you. That is dissolution of firm. So here I'm just changing the constitution. I'm still looking at you. I will be admitting new partners and changing my partnership. Here I'm just running away home and I'm closing everything, taking my bag. I am closing the firm. All right. So these cartoon pictures are just to help you to remain, understand and stay in track with the chapter. So these are the points of differences. Yes, you have to learn these 5 points of differences. Let us just go through one by one. So dissolution of firm means discontinuance of business, means the business is now stopped. We are no longer going to do the business with in the partnership. A firm has 3 partners, A, B, and C, and if the relationship between all the partners end, then whole of the firm get dissolved. Clear ho gaya, dissolution of firm. All the 3 partners are deciding to dissolve the firm. They do not want to continue. Firm comes to an end. Here the business still continues. It says it does not affect the continuation of the business. Only reconstitution is happening. So there were 3 partners, A, B, C. D has joined as a partner. Now the old partnership will get dissolved and new partnership will be formed between A, B, C and D. Samajh gaye, dissolution of partnership is only a reconstitution. Dissolution of firm means finished. End, close. So here it involves winding up of the firm. Winding up means closing of the firm. Winding up ka matlab hota hai closing of the firm, and all the assets will be sold off and liabilities will be paid off. We will sell off the assets of the business and pay off the liabilities and everything will be closed. All the books of accounts get closed. Here it is only a reconstitution. Therefore, what do you do in your profit and loss account? When dissolution of partnership happens, we only do the re-evaluation of assets and liabilities. We need to re-evaluate. We need to evaluate our assets and liabilities on the date when a partner is joining the firm. So here, dissolution of partnership re-evaluation happens. In dissolution of firm, realization of assets happen. A firm may also be dissolved by the order of the court. So today we are going to do specifically section 44, which talks about what are the specific cases where court can also order for the dissolution of the firm. However, partnership is never ordered by the court. Court will not tell you, no, please hire this person or make this person retire or this person is going to die and dissolution of partnership will happen. Dissolution of partnership is not ordered by the court, but firm's dissolution may be ordered by the court under section 44. It necessarily involves dissolution of partnership. Obviously, when the firm is coming to an end, partnership is also coming to an end. But children, does it involve dissolution of partnership? May or may not involve dissolution of firm. You can still stop the firm also, or say, for example, a death of a partner and you thought that partner has died, let's end this partnership now. So dissolution of partnership may also involve the dissolving of the firm also. Or you thought one of the partner has retired, but still the remaining partner want to continue the business, then also you can do. So you may end the firm or you may still continue the firm. It's up to you. Here the final closure of books is happening. All the books of accounts get closed, assets sold, liabilities paid, everything is finished off, khatam. Dissolution of partnership does not involve the final closure. We are just maintaining our books of accounts. Only new entries will be made because new partners have joined the firm, or maybe some partners have left the firm. So revaluation of assets and liabilities will happen. Clear hai? So please learn these 5 points of differences between dissolution of firm and dissolution of partnership. Now, children, after this topic, we will go to the queries. I am not jumping to the queries in between. Otherwise, section 40 to 44 will be left undone. All right. Okay. Yes, that's correct. Just Preet, Neelam, Aditya, all of you. Modes of dissolution of firm. Now, let us understand what are the modes, what are the methods in the morning we understood mode of registration of the firm, कि firm को register कैसे करना है. Now we are going to understand modes of dissolution, means firm को end कैसे कर सकते हैं. How can we close the firm? Section 40 to 43 tell you without the order of court. So 40, 41, 42, 43 specifically tells you where the court does not need to interfere. And section 44 will tell you how court can end the firm. So section 44 clause A to G specifically deals with the cases where the court can order about the dissolution of the firm. Let us understand section 40, 41, 42 and 43 first. So number one, it says dissolution by agreement. So section 40. It says a firm may be dissolved with the consent of all the partners or may be according to a contract between the partners. What does it say? It says firm has decided to close itself. So ABC Associates, there were a firm who was continuing the business with the name of ABC Associates, and they said now we want to close the firm. So it says it entirely depends upon the agreement. It entirely depends upon the contract which they have made between the partners. So if the partners have agreed that if you want to dissolve, then if all the partners agree, they can dissolve the firm. The most important line to remember over here is consent of all the partners is required. If only few partners are agreeing and the other partners are not agreeing, then it cannot happen. Say, for example, A and C want to wind up the firm, but B has not given its consent. Then dissolution is not possible. Dissolution can happen only with the consent of all the parties. So section 40 typically talks about the dissolution by agreement, means whatever agreement partners have decided to do. So if they have contracted that maybe by an agreement, if it is written in a partnership agreement that with the consent of all the partners will dissolve the firm, then all the partners should agree for this dissolution, and then yes, all the partnership will get dissolved. Dissolution can also be inferred from the circumstances as closure of the business or final accounts. So I already told you, once the firm is coming to an end, all the accounts, all the final books and accounts will come to an end. The business gets closed. So all the partners should be ready in case of section 40 to dissolve the firm. Clear ho gaya? Section 40 is very, very simple. It is only simply talking about the agreement. Contract between the partners means a contract already made, means the agreement which you have signed between the parts. Section 41 is interesting. It says compulsory dissolution. Now, what is the meaning of compulsory dissolution? It says something has happened in an event which makes the partnership either unlawful or now it is no longer possible to continue the partnership firm. Say, for example, there was a firm which was carrying on the business of trading in a particular chemical. And now law has been passed which tries to put a ban on this particular chemical. So there is a firm, PQR Associates, and they are doing a business from 10-15 years, and they were dealing in a particular kind of a chemical. The business is to manufacture that particular chemical. Now say that particular chemical or drug has been banned by the government. Government has passed a regulation that now you cannot deal with this particular chemical. Now it says it has become very much compulsory for PQR Associates to dissolve the firm because it has become illegal to do the business. Now the business becomes unlawful. So they will have to compulsorily dissolve the firm. Compulsorily means ab zaruri ho gaya. You have to dissolve the firm. So there is no another alternative for you. So if any kind of undertakings become unlawful, illegal, then you have to dissolve the firm. Another example which I enjoy sharing with my students is your plastic bags. So you know now plastic bags is generally banned. So if it was your business to manufacture 100 plastic bags and supply to another state, so since law has been passed which bans this usage of plastic bags, so you cannot do that kind of a particular transaction. So sometimes it says compulsory dissolution. Section 41 says any change in the law has happened, any amendment has occurred due to which now the partnership business has become illegal, unlawful. Now you cannot lawfully do that kind of transaction. Therefore, you have to wind up the firm. Section 42 deals with contingencies. Children, you remember contingent goods? The ship in which the goods were sailing, there was a contingency. The ship might get sink on the way. It might not reach the port. So there was always a contingency, uncertainty. So contingency also means uncertainty. Today's chapter, when I teach student dissolution, I tell them it is more like your English chapter. It has more of the words usage which you need to understand. So it says uncertainty, something which is not certain, something which is not sure as of now. So something which you are not sure, it leads to contingencies. So section 42 says, subject to contract between the partners. Now, what does it mean? It says, what the partners have agreed, that is something different. So if you and me are partners, we have agreed that we are never going to dissolve the firm, then keep on continuing it. If we have decided that we will continue the firm for 1 year, then the firm will come to end after 1 year. But if we are partnership at will, then it is a separate story. So it is subject to contract between partners, means whatever the partners have decided, that is something different. But section 42 specifically give you the cases of contingencies, or you can say the cases of emergency, uncertainty, where the firm comes to an end after the expiry of this period. So number one case is, if the firm was constituted for a fixed term, then it comes to an end on the expiry of the term. What do you call this partnership? Can you tell me? Section 42 is talking about the first point. It says, yes, Lakshmi, 6 marks question. If you answer it in the same way, you can get those marks. Adjudication, Kusum Rawat, it means once you're declared insolvent, the court will pass the order of declaring the person insolvent as per the case. Yes, please answer me, children. What do you call this partnership under section 42.1? It will talking about your fixed partnership. Excellent, those who have given the correct answers. I don't know where are others wondering. They're still bothered in the queries. You're not sending me the answers, children. So it is talking about your fixed partnership. So if fixed partnership is formed for 1 year, after 1 year, it will come to an end. So that is section 42 dissolution. Very good. Aryan Agarwal, particular partnership is the second case. I was asking for the first one. So first one is talking about your fixed partnership, and if the partnership was constituted for one or more adventure, then that means it was a particular partnership. After the end of that particular event, partnership will come to an end. Very good, Dinesh, Dipanshi, Manisha, Mohammed, Abdul, Sabreen, Vanchika, Bhumika, Vidya, Pushpa, Kusum. Very good. All right. Now, the third case is death of a partner unless contrary contract. Now, this is very interesting. So there were 3 partners, A, B, and C, who were running a firm for 10 years. Now, Mr. C died. When Mr. C died, section 42 will get applicable. It says if they have not decided anything else, the firm will come to an end. So death of a partner, simply it's an uncertainty which happens, happening or non-happening of event. That's absolutely correct. Dhruv Khandelwal, that's correct. Children, somebody is just writing, please take my name. For 100 times he has written and the name is not appearing. I'm sorry, there is no name. So it's very difficult to take the name. Mohammed Ahmed, that's correct. Vanchika Gupta, contrary means something different. Something not related to that. So if we have decided, so if there was a contrary contract where we have decided that even if the partner dies, we will continue the firm, then section 42 will not become applicable and A and B can continue the firm. समझ गए? A, B, C, D, 4 partners. A died. Section 42, firm gets dissolved. Contrary contract means if we have decided that firm will still continue, then A, B, and C and D will still continue the firm. Okay. Samyak. Okay, Samyak. Let's go ahead. And the last one is adjudication of a partner as an insolvent. I have not even reached at this point and everybody was asking about adjudication. मुझे पहुंचने तो दो बच्चा उस point पे. So if any partner, adjudication means declared. So if any partner is declared insolvent, court declares person insolvent. What is the meaning of insolvent? That means now this person is not having sufficient assets to pay off its liabilities. All right. So if you are not having sufficient assets to pay off your liabilities, the court passes an order declaring you insolvent. So adjudication means declaration of person as an insolvent. Now this is also kind of uncertainty. Can you say today that tomorrow that person will be declared insolvent? Or can you tell today that Mr. A will die tomorrow? So all these are contingencies. We are not sure about these kind of cases. So it says death of a partner or insolvency of a partner also leads to what do you call this? Dissolution of firm. Nafisa, we are talking about section 42 only, so please pay attention. Partnership at will, Abdul, that is a separate story. Section 43 will become applicable in case of partnership at will. Okay. Samyak Jain, I hope you're understanding now. All right. So if the partner is declared insolvent, ABC Associates, there are 3 partners and A became insolvent. What will happen to the firm? Tell me, fatafat se. ABC are partners in a firm, ABC Associates. Mr. A becomes insolvent. Will the firm continue or will the firm get dissolved? Answer me, children. Shambhavi, that's correct. Vanshika Gupta, that's correct. Yes, Vanshika Gupta, I'll meet you in the Companies Act now. Don't worry. Okay. So what will happen to the firm? Yes, definitely, that's correct, ma'am. The firm will get dissolved under section 42. And if we have agreed there was a separate contract between the partners that still we want to continue, then the firm will still get continued. So section 42, 4 cases we have understood. For a fixed and particular partnership, section 42 becomes applicable. And in case of a death and insolvency of a partner also, the firm gets dissolved under section 42. And section 43 says dissolution by notice in case of partnership at will. In the morning when you answered me, you have already understood that if the partnership is formed at will, then one of the partner can communicate his intention, means a notice in writing has to be given to the another partner that we want to dissolve the firm. And what will be the date of dissolution? It says the date which is mentioned in the notice and not the date on which the notice is given. See, for example, if on 5th February 2022, that is today, I gave a notice to my another partner. So Harleen and Shivam have formed a firm and it was partnership at will. So I sent a notice on 5th February 2022. I sent a notice to Shivam that let's dissolve the firm from 10th February 2022. Then what will be the date of dissolution? Come on, tell me. On 5th February 2022, Harleen ma'am gives a notice to his partner that we want to dissolve the firm and it's partnership at will. And in the notice, I have written the date of dissolution, 10th February 2022. What will be the date of dissolution? Mayur Chandan Kusum, you were absolutely correct in the previous answer. Pushpa Muhammad Ali. So Pushpa, adventure means if any activity I've thought that we both will be, forming a partnership for a certain period and say for a particular exhibition, we want to put up a stall. So now after the end of that stall, so we thought that for 3 weeks, we'll be putting up a stall. So that was a particular adventure activity for which we formed the partnership. Now after 3 weeks, that partnership will get dissolved. That is the meaning of particular partnership. 10 February 2022 is the correct answer. Vidya, Kusum, Mohammed, Sridhar, Abdul, Suja, Lakshmi, Nafisa, all of you are correct. Piyush, Sarvesh, absolutely correct because this is the date which I have mentioned for dissolution. And if children, I have not mentioned any date. So I rub this date. So I simply gave a notice of dissolution in writing on 5th February. Then law says now your date of dissolution will be 5th February 2022. That's the date on which you have communicated. Clear ho gaya? Now let's move to section 44. So section 40, 41, 42 is absolutely clear. Refer to my notes. I have briefly explained you all these points and whatever examples I just shared with you, I hope you kept writing it down. It becomes simple. Now let us understand section 44. So dissolution by court. Now law says there are certain cases, clauses A to clause G, where the court can come and tell you that you need to off your firm. Now you need to dissolve the firm. So what are those specific cases? So children, you can write down, these are the cases where the court gives you the order of dissolution. Cases where court orders the dissolution. Okay, there are specific cases. Number one case, partner becomes unsound mind. So if any partner, remember partners competent to enter into a contract. So if the partners are not competent to enter into a contract, the partner has become unsound mind. He is not capable of taking decisions. Obviously, our other partners can go to the court and they can ask for the dissolution of firm. Can you continue partnership with the person who has become mad? Person who is not having a sound mind? You have to take important decisions when you're doing a business. So capability to enter into a contract is very important. So if any partner has become unsound mind, maybe because of some health issue, his mind is not working properly, then the other partners can file an action in the court and they can order the court for getting the firm dissolved. And my dear children, if you ask me what will happen for the remaining partners, if they want to start a new firm, they can still continue with a new firm. So there are three partners, ABC Associates. Mr. A became of unsound mind. Say there was some health issue and Mr. A became mad. So now law says if Mr. A has become mad, then B and C can file up an action in the court. B and C can file an action in the court and they can say that we want the firm to get dissolved. And B and C can separately set up a new firm and they can do a business. Okay. But any partner has become unsound mind, that particular firm will get dissolved. Similarly, permanent incapacity. There are three partners, Mr. P, Q and R. So Mr. P met with a very severe accident and whole of his body became paralyzed. Now Mr. P has become permanently incapable. He's not capable to do a business. He cannot get up from the bed. He's entirely on a bed rest. So if any such kind of mishappening has happened with any of the partners, Q and R can file an application in the court and they can say that one of the partner is physical disability or illness has occurred. Therefore, we want to get the firm dissolved. Then court may order the dissolution of the firm. Point number 3 says guilty of conduct which is affecting the carrying of the business. Now it says typically talk about the case of misconduct. So I told you children that when you're doing a partnership, you have to be very careful. You cannot use bad language. You cannot, have a negative impression. So if one of the partners, Mr. A, is behaving in a very bad manner, which is actually affecting the reputation of the business. So whenever the customers comes to your shop, Mr. A is shouting, he doesn't have manners to behave, he yell at the customers, he doesn't make payments to the creditors on time. So if any such kind of misconduct is happening, the other partners can go to the court and they can ask for the dissolution of the firm. So I'll simply read from the study material. It says where any partner other than the partner suing. Other than the partner suing means the other partners are filing a case that please dissolve the firm. So when a partner, say for example, Mr. A, if he is found guilty of conduct which affects prejudicially the carrying of business. What is the meaning of prejudicially? Means it is having a negative impact on my business. My business is getting a negative reputation. It is affecting the good reputation of my business. Then the court may order the dissolution with regard to the nature of business. It is not necessary that the misconduct might relate to the conduct of business. The important point is the nature of the business has to be seen, whether it is a kind of misconduct or not. Now let's take a very interesting example. Say Mr. A, who is the partner in my firm, is a very angry man. So uski nature hi aisi hai, like at home also he is always shouting, yelling and he misbehaves. But when he comes to his business, he is very quiet. He is very calm. He is behaving well with others. Then children, then his image is not affecting my business. So if only his image is affecting my business, then only I can ask for the court's dissolution. Just general, I'm not liking the person cannot be the reason for dissolution of the firm. Okay? So misconduct has to be proved. Another point is willful. Willful means जानबूझकर, मर्जी से. Willful or persistently. Persistent means continues. What is the meaning of persistent? Persistent means continuous breach of agreement. So if I'm breaching the agreement, I'm not obeying the instructions, I am not fulfilling my obligations, then also the dissolution of firm can happen. So the person who is breaching the agreement, say for example, we have made certain kind of partnership agreements, we have made the agreements with the third party. So if any of the partner is not fulfilling those agreements, then the other partners can go to the court and request for the dissolution of the firm. So what are the 4 cases given on the breach of agreement in your study material? Embezzlement. What is the meaning of embezzlement? Please write down. Embezzlement means any fraud. Embezzlement means any fraud if any partner is doing. Keeping erroneous accounts. Erroneous accounts means inaccurate. So I am not showing a true and fair picture of accounts. I am giving inaccurate accounts. Holding more cash than allowed. So if my firm has decided that we will only be keeping 1,50,000 cash, but you're still holding 2 lakhs of cash, that means you're not fulfilling the agreements, you're breaching those agreements, then the court can order the dissolution. Refusal to show the accounts in spite of repeated requests. So other partners keep on requesting, but you're hiding the copy of accounts. You're not showing it. You're not allowing them to inspect the accounts. In such a cases, then the partners can go for dissolution. So study material has given you a very beautiful example. It says if one of the partner is keeping erroneous accounts, erroneous means inaccurate accounts, and omits to enter the receipts. We are earning a revenue and he's not making an entry. He's making errors. He's not making the entries. Or there are continued quarrel between the partners. They're always fighting among each other. Then such a state of thing destroys the mutual confidence of partners. Therefore, the firm can get dissolved. So now examiner can give you case studies, children. Such kind of descriptive case studies can come that AQ, PQ are partners, but Mr. P and Q are having continuous quarrels. R is not forming a trust on them. In such a cases, dissolution can happen by court. Section 44 can be made applicable. Either under Section 44D or under Section 44G can become applicable if the dissolution is just and equitable for the firm. Another point is transferring whole of his interest in the firm to third party. So Section 29, I told you, transferee has certain rights, but if you're transferring all of your shares, then existing partners, if they are not comfortable, they are not giving their consent, then he can go to the court and he can apply for the dissolution of the firm. Other partners have to be satisfied and consent has to be given if Section 29 is to be made applicable. But if you are transferring whole of the interest and other partners are not comfortable, then they can apply for the dissolution of the firm. Another one is loss in the business. If you're having perpetual losses, means your business is not doing profits at all, you're continuously suffering losses, then the court can order for your dissolution. And Section 44G, children, typically talks about the points. I'll just take the points over there because generally you raise the queries related to those points only then. What is the meaning of this word? Okay. So Section 39 to 47 we are doing. Everything is clear till Section 42. 43 is also done. Now, these are the points which we are talking about. Section 44, keeping erroneous accounts, transferring of the interest. We have understood continuous loss. Now, these are the 4 points where you talk about the just and equitable grounds. Now, it says if court feels that, okay, fine, it is absolutely correct to dissolve the firm, then the firm has to get dissolved. For example, deadlock in the management means you are not able to manage your firm. Everybody is having a fight. AB is saying something else. C and D partners are saying something else. They are not agreeing to unanimous consent. They're not having good decisions. They're always having a fight among each other. Then there is a deadlock in the management, means the management is not running properly. Then the court may order the dissolution. All the partners are not in talking terms. They are always fighting. Mutual trust is not there. Loss of substratum. Substratum means we have lost faith in each other. So, for example, there are 3 partners, A, B, and C, and Mr. A is always doubting on Mr. B and C. And Mr. B is always suspicious about Mr. A's transactions. That means loss of faith. Loss of substratum means loss of faith, loss of trust. Vishwas nahi hai. So, agar hame vishwas hi nahi hai, we cannot do any partnership. So I told you, children, partnership is the relationship of trust and confidence. If you don't have any trust and confidence, court may order the dissolution of the firm. Or any of the partner is doing gambling. Trading is allowed, but if you're doing any gambling kind of transaction, then also the court can order. If you're found guilty for gambling activities, court may order the dissolution of the firm. All right, children. So section 44, you have to remember these are the cases where court does not order. 40 to 43 and 44, court specifically orders for the dissolution of the firm. Now, section 45 to 55 is very, very general. It typically talks about what are your liabilities after the dissolution of firm happens. And this is one of the questions which has come in your exam also. In the morning, I was showing you section 48. Let me just show it to you from the notes also. So these examples, case laws I have taken, you can just give it a fair reading where it amounts to dissolution, where it amounts to only reconstitution. These kind of points make your doubts clear about the difference between a dissolution of firm and just the reconstitution of the firm. So section 45 says liability for the acts of the partners done after dissolution. So now my children knows until public notice is not given, the firm continues to remain liable. The only exception is estate of a deceased partner who is not known as a partner will not be liable. So if any deceased partner has died, the public notice is not necessary. Similarly, a dominant partner also is not required to give any public notice, and they are not even liable for any subsequent acts of the firm. However, notice can be given by any of the active working partners. Then is the right to have business wound up. So after the dissolution, all the assets need to be disposed of, liabilities needs to be paid off, the business needs to be completely shut down. Continuing authority of the partner. So it says whatever authority we have to exercise in order to dispose of the liabilities, we have to do those kind of rights of exercise has to be done. Here comes your specific question which has come in the exam also last time, which I was showing you, mode of settlement of accounts. Now, law says you have dissolved the firm. Everything has happened. So, examiner specifically asked you, how are you going to settle the accounts? Remember, I showed you in the morning examination paper question, the 2021, it has specifically asked you, what are the mode of settlement? So, section 48 will become applicable. It says, if the firm is having any losses, so there were losses of rupees 10,000. So, now how are you going to pay for these losses? It says, first, the payment will be made out of the profits. Then we use the capital bought in by the partners, and still if required, the personal assets have to be bought by the partners in order to pay off their liabilities. So the partners have unlimited liabilities. He's just trying to tell you what is the mode of settlement, how you have to use the assets of the business to make the payment for the losses. So first you will be using the profits, then you use the capital of the partners, and then you use the personal assets of the partners. And it says how the assets of the firm has to be used. First, we will be making the payment to the third party. So whoever are the third party's creditors, first we will make their payments. Then we will make the partner's entitlement apart from their share contribution. So if any partner has lended a loan to the firm in addition to their capital, then we will make the payment to the partners. After that, whatever amount is remained, we will pay for the capital of the partners, and balance is shared in the PSR, means profit sharing ratio. So first we use the payments from profits, capital of the partners, and then their personal assets. How we make the payments? We sold off the assets of the firm, we make the payment to third parties, then any payment to the partners which is pending, then we pay off their capitals, and the balance is given to the partners in their profit sharing ratio. Okay, this is just the summary of section 48, which is given in your study material. And section 49 simply talks about payment of firm's debt in separate days. So it says whenever the property of the firm is sold, first we will pay the firm's debt, and if there is any surplus means agar fir bhi kuch bach gaya, balance, that will be used for the payment of the separate debts of the partners. Say, for example, the firm's assets are sold for rupees 1 lakh. Firm's assets are sold for rupees 1 lakh. And the liabilities of the firms are 1,10,000. And you also have 10,000 debts of the partners. So now it says whole of the 1 lakh will be used to pay the liabilities of the firm, and nothing will be given to the partners. But if the liabilities of the firm were 90,000, So the liabilities of the firm were 90,000. Now you can use 90,000 to pay off the firm's liabilities, and balance 10,000 can be utilized to pay his separate liabilities. Similarly, it says if any partner's property is to be used, then first it will be used to pay the separate debt, and any surplus, if there, will be used to pay the firm's debt. So firm's debt, pay the firm's liabilities, then pay the separate debt. If the partner's property is to be applied, first we will make the payment of the partner's debt, and if there is any balance, we will be using it for the firm's debt. Clear? With this, we come to an end. And yes, I know the MCQs are also there. I'm not going to leave you before doing the MCQs. So here comes your MCQ questions. Khushi Varshne, I explained all the points of substratum and deadlock also. It means if you're not having a good relationship, if you're not having faith and trust in the partners, then partnership can be dissolved. Now quickly read these questions and please mark your MCQs and send me the answers. Partner by holding out is declared according to the express agreement or by giving a notice in writing with the consent, or he represents himself. What is the correct answer? Yes, sir. Am I audible? Yes. Yeah, I'm continuing. Please answer this first question, children. The second one, ABC and Associates is an unregistered firm. What happens then? It cannot claim set on, set off, set on and set off, or none of the above. Meaning of embezzlement, Sunil Yadav, it means doing any kind of fraud. If you're doing, say for example, you have stolen the cash from the partnership firm and you have taken it home. So you have done such a certain kind of fraud with your firm. Therefore, it is not done and the firm can be dissolved. Thank you so much, Priyanka. Happy Basant Panchami to you also. Thank you, Manisha. I hope Siddhi, embezzlement is now clear. Any type of fraud happening in the partnership firm, it means. Mohammed Ahmed, it is applicable to the entire firm, section 44, dissolution of firm we are talking. No part, compulsory dissolution has a separate cases. Section 44 typically talks about the dissolution by court. Okay, let's go to third one. Registration of firm is complete when complete application for registration is filed. The registrar files the statement and makes the entry in the record. The registrar gives notice of registration to all the partners, or when the court records the statement and certifies the entries in the register of firms. Which is the correct one? Bhumika, Parth, Manisha, Mohammed Ali, Pooja, Priyanka, Nikhil, Sonu, Shaw, Aditya, all of you are giving correct answers. Muskan, Sarvesh, Hira, Mansi, Pooja Swami, very good children. Anchal, Karishma, Sameer Singh, Sunil Yadav, Lakshmi, Alfia, Sanyam Jain, Samyak, Sameer Singh, Aryan Agarwal. Good. All right, shall we move ahead? Registration of the firm is compulsory, optional, occasional, or none of the above? What do you think? For the third one, fourth one, what do you think? Abhinav Kumar, that's correct. Okay, let's have the answers for the first four one. Partner by holding out is declared by express agreement, never. By notice, never. With the consent of all the partners, never. When he represents himself as a partner, even if he's not. All of you have given the correct answer for this one, so that's great. Partners in an unregistered firm, you cannot claim the set-off. Please, the set-off is the correct word. Set-on is just to confuse you. It is nothing about like set-off. Samyak Jain, that's correct. Your answers are correct. I don't know why you are writing so many times. Samyak Jain. Samyek Jain. Are you happy now, Samyak Jain? Yes, Aditya Pal, you can send your query. No doubt. No problem with that. Okay, this one is clear. So now third one, registration is said to be complete. Who is the correct one who's sending this answer? Samir saying Jaspreet, Alfia, Samyak, and Anshul, Aditya, all of you are correct. So when the registrar files the statement and makes the entry in the register of firms. So B is the correct answer. Recording of the entry is the date when the firm said to be get registered. Court has nothing to do. D point was just to confuse you. And registration of firm is compulsory. What do you think? It's optional. B part is absolutely correct. Registration of firm is never compulsory. But in next week when you'll do LLP, you'll understand LLP is definitely compulsory. Samyak Jain is still writing. I think he cannot hear our voice. Ravin Kumar, Sridhar, Khushi, all of you are correct. Neil Yadav, Sujal Gupta, Sonu, all your answers are correct, children. So I think let's stop here, or you want to do more MCQs? This presentation will be uploaded anyways in your portal also. Okay. Reconstitution takes place on what? Reconstitution of the firm takes place on admission or retirement, death or expulsion of a partner, or all of the above. So the correct answer is, okay, Sujal Gupta, I'll just take up. All of the above is the correct answer, children. For the fifth one, A, B are partners and the wife of A and B had a fight in club and B was expelled. So is it justified? What do you think? Is this partnership expulsion justified? Lakshmi, you can see the questions again from the recorded lecture now because we're already on sixth question. I'm still confused in the above point. Sujal Gupta is asking about the when A died, reconstitution takes place and fresh registration is required. So please listen carefully, Sujal Gupta. The example given in the study material, there are two different cases given. One, it says if the partners had died, no fresh registration is required because the remaining partners were already registered with the firm. Second case is where a new partner is joining the firm. His name has to be taken in the record in the register of firms. Then only the firm will be considered as a register firm. Therefore, a fresh registration is required. All right. Chandan, Sunil, Gopal Krishnan, Neelam Yadav, Mansi, Aryan, Sonu, Sujal, all of you are correct. Hira, Samyak, Gopal Krishnan, all of you are correct. No is the correct answer for the sixth one. All right, let's go to another one. Minor as a partner can be made liable to outsiders, yes or no? Sonu, Mohammed and Sunil have said, ma'am, we want more MCQs, so we are doing more. H. Om Prasad, if the partner has died, then section 42 dissolution we have to see, unless and until we have not agreed otherwise. Partner can be made liable to outsiders, children, yes or no? The answer is no. Partners can never be, minor can never be made as a partner liable to the outsiders. What is the time period for giving a public notice for a minor on attaining majority? 3 months, 2 months, 6 months? What is the correct answer? So the correct answer I'm giving, you can mark it. 6 months is the correct answer because we are running ahead of the time. All right, children. So I hope with this we come to an end to the registration and dissolution of firm also. And after this, you will be starting with your LLP and I meet you again for your Companies Act. Still, if you had any queries for partnership, feel free to send it to me. I'll try to resolve when I start the Companies Act with you. But I hope I have answered almost all the queries we have taken up in the class today. And your book is just go through the entire syllabus. Just read your chapter number 1, 2, and 3 of Indian Partnership Act. Chapter 1 and 2 is already there on the website. I have uploaded the notes. Chapter 3 also. By tonight, you'll be able to see chapter 3 also. So please give a fair reading to the notes and try to solve one of these suggested answers yourself. So I've told you 3 questions come from partnership. Question number 3, part A. Question number 4, part B, and the last one for 4 marks. So 6 plus 6, 12 plus 4, 16 marks paper comes from partnership. Please revise it thoroughly, prepare for it, and I'll get to see you in the next week in Companies Act. All right, students, goodbye, stay blessed, keep revising, and don't worry if you have any doubts, I'll take up whenever I meet you next, all your doubts. All right, goodbye. Thank you so much.